We will hear argument this morning in Case 24-1063, Hunter versus United States. Ms. Blatt.
Mr. Chief Justice, and may it please the Court, all contracts are subject to defenses. So appeal waivers are also subject to defenses and can be excused in more circumstances than the two recognized below. The government argues that no contract defense can apply to knowing and voluntary appeal waivers, no exceptions. But if appeal waivers bind defendants under contract principles, they can be excused under contract principles. A contrary approach is anathema to our criminal justice system. No appeal for sentences above the statutory maximum based on race, religion, national origin, tribal status, or pure vindictiveness. No appeal for pregnancy bans, castration, or compelled church attendance either. These scenarios are all real cases. Or take this case. Only the most paramount government interest overcomes the fundamental right to refuse medical treatment. But Hunter was sentenced to a mandatory medical condition even though he had no mental health issues, let alone one connected to the crime or related to any sentencing goal. Defendants bargained for caps on their sentencing exposure. Those bargains are destroyed by plainly unlawful sentences that are totally outside the realm of plausibility of either party. Now, Floodgate's concerns are belied by decades of experience in the 11 circuits that reject the Fifth Circuit's rule. Applying defenses to appeal waivers maintains the status quo. Contract defenses are narrow by design and rarely satisfied. Appeal waivers will continue to bar the vast majority of alleged sentencing errors, guidelines miscalculations, insufficient explanation, or misbalancing under 3553A. But contract defenses may be satisfied in the rare case of clear legal error and punishment unauthorized by statute or that violates the Constitution. At a minimum, this Court should remand on the second question presented. I welcome questions.
Ms. Blatt, if you can waive constitutional rights or statutory rights, why can't you waive these contractually rights that are statutory here?
You absolutely can waive the right to appeal, and there's an appeal agreement. But the issue here is, absent this plea agreement, which is a contract, the defendant could just walk away. The only thing that is binding him to the waiver, and the government is asserting the enforceability of the appeal waiver by contract. I don't think there's any dispute that the plea agreement is a contract. If you waive your right to trial when you at the arraignment and just say, I waive my fundamental right to trial, that's a pretty big waiver. Tomorrow you can get up and say, you know what, Judge, I think I want a jury trial. You can just revoke it. But here there's a plea agreement, there's a contract. The government has to rely on the contract principles. The government gets out of plea agreements by relying on contract defenses, and there's just no rational or it's just inexplicable that you would not apply contract defenses to this contract when you do to all others.
In this case, could the government simply void the agreement and proceed with the 10 counts?
Yeah, I don't think so, but here's why. The government has, in many cases, asserted frustration of purpose and did exactly what you said. I think here, because the government has no interest and is not defending the mandatory medication condition, there's just no countervailing principles. Now, the government has not disputed it can allege a breach of the plea agreement, and that would result in an invalidation of the plea. The government just doesn't dispute that. That's why defendants so rarely bring these appeals, is because they run a substantial risk of exactly what you're saying. We would try to argue that there's no breach based on the fact that the judge told him he had a right to appeal. And even if it is a breach, you know, it's justified by defending the contract exception, and the government doesn't have any countervailing interest to invalidate the whole agreement. And that's all the stuff we would fight on remand. Here we're cut off because the Fifth Circuit has this categorical rule that although it's a contract and you're denied the benefit of the bargain with sentences that exceed the statutory maximum, it allows no other exceptions.